Hello, everybody. This is Junius. I am happy to talk about the latest saga concerning about the oath taking by the two lawmakers. They are Mr. Leung Chong-hang and also Ms. Yao Wai-jing. Both of them could have been my colleagues and doing service to the people in Hong Kong. But due to the fact that on the 12th of October, when we all were supposed to go through a solemn business to make oath and to pledge our allegiance to the SAR, these two persons filed up their oath taking. In that they basically said something not in accordance with the statutory requirement, and they said something out of the context, addressing China as Chila. That brought back very painful part of the history out of the memory of some older generations, and so that was totally inappropriate. She even said something really bad by using the foul language in describing the People's Republic of China. Instead of saying Republics of China, she used a foul language to substitute it. That also was a very big mistake she made. So in the circumstances, both of them were suspended from assuming the duty, and both of them now not only to be prevented from participating in our electrical meetings, committees meetings, they are now even subjected to a court proceeding. The Chief Executive and also the Secretary for Justice had applied for a judicial review against the decision of the President of the electrical. The MPCSC in Beijing is minded to interpret the basic law in order to make way for the court in High Court to make the appropriate decision in accordance with the like. Whether or not it is appropriate for the MPCSC to make the interpretation at this sensitive time, there are different school of thoughts. Some people said yes and some people said no. However, I think I would leave it up to the general public to decide. But from as far as I am concerned, by looking into the Hong Kong situation, since the reversion of the sovereignty back to China, we have gone through 19 years. But during this past 19 years, we only had happened 4 times for the interpretation of the basic law, and very often on each occasion it has its own reason to back up, and it brought up the general effect to be of positive with positive impact on Hong Kong. So even if assuming that this interpretation about some of the provisions in basic law which may have some impact on the existing case, I would not see it too negative, but rather it may make way and pave way to enable the court to seize the issue and seize the matter more effectively and efficiently. So therefore, if I may say something to the general public in Hong Kong, that their interpretation, the interpretation of any provision in Hong Kong, it is not just a matter which happens every day. It only happens when there is exceptional circumstances which would justify it happen. And given the experience that we had for the last 4 years, we know that all this are fully justifiable. When looking ahead, even if there should be another interpretation of some of the provisions under the basic law to enable the case to be effectively discharged, I do not see that as a negative of any negative impact, but rather it would be of something good to Hong Kong.